My name is Annabel Bazante, and I'm an attorney specializing in trusts and estates and elder law. I have an office in Elmont. I have an office in Garden City. Of course, I'm really not doing much in either one of those offices these days. And I also now have an office on the World Wide Web, and you're all here. So, as I said, I specialize in trusts and estates and elder law. This means that I provide wills, trusts, powers of attorney, healthcare proxies, and living wills to my clients. I do surrogates court litigation. You may find yourself, but I hope you don't, involved in a will contest or a trust accounting that you have to defend or pursue your own rights. I'm adept at that type of representation as well. And then as an elder law attorney, I do a lot of guardianship work. I help people plan for Medicaid eligibility for home care or institutional nursing home care. And I also prepare Medicaid applications. I'm proud to say that I grew up very close to the Cuomo family in Hollis, Queens. He grew up in Holliswood. I grew up in Hollis nearby. I didn't know him at the time, but he's doing such a fine job of sort of leading New York State through this crisis that I'm proud to mention that. I went to Stuyvesant High School, and after I graduated from Stuyvesant, I went to the Ivy League University of Pennsylvania, and I did very well at Brooklyn Law School. So just so you know who you're talking to, who you're spending your evening with. More important than any of that, though, I pride myself on making my work, my legal services, available to people regardless of their resource level and regardless of their level of sophistication or background. I find that it's important to provide legal services not only at a reasonable rate, but also to communicate what can sometimes be confusing, difficult topics in an understandable way. So, for example, this evening, if you find that I'm using language that is unfamiliar to you, or that I'm stumbling over my words because I'm a little nervous, or whatever the reason may be, feel free to set aside a question and ask us. And if you don't get a chance this evening, we're going to be providing you with my contact information so you can contact me at a later date, because I'm here for you. I look at these library presentations as a community service that I'm honored to provide. Tonight's topic is essential personal planning during the COVID crisis, and this will be part one in a series. Why should we plan? Well, I heard from a very wise person that if you fail to plan, you plan to fail. That might even have been Weight Watchers, but I find that it applies in a lot of different areas of my life. So that's why we plan, because we don't want to fail. Essential are the planning suggestions I'm going to be sharing tonight. Essential, I see them as vital. They're vital to help you avoid losing opportunities to enhance the comfort and the well-being of you or your loved ones during this crisis, and also perhaps to save the value of certain assets should you or a loved one find yourselves needing to apply for Medicaid assistance for home care or nursing home stay. Personal planning, well, my talk tonight is going to be addressed to each and every one of you, for yourselves, but also for you who find yourselves as caregivers, whether you are formally in a caregiver role for a loved one or another person, or if you just have family members who need help getting through this crisis. I'm going to talk a little bit about general changes in the law, and some of them are very, very recent. Some of the recent changes to the law that affect trusts and estates and elder law are going to be temporary, and they're going to phase out along with the COVID-19 lockdown that we're experiencing now. Other changes to the law that affect my practice area are going to be much more permanent in nature. And actually, one of these changes is going to create quite a bit of convenience and roadblocks for some of us to get through as we're trying to get our loved ones an aid paid for through social services. So of these recent changes to the law, some of which came as a result of the recently passed New York State budget and others which came as a result of executive orders issued by our governor, the first one I'm going to touch on, but very briefly, has to do with community Medicaid benefits. Now, if you have never heard the expression look back period, then just excuse me for a moment, because I'm not going to go too deep into that tonight. That's going to be addressed more in part 2 on May 28th. But I just need to let you know, because this is a very new change in the law, that whereas there has been an applicable 60-month look-back period that applies for people applying for nursing home Medicaid benefits, there is now also a 30-month look-back period that applies to community Medicaid. That means that, you know, a couple of weeks ago, or even today, because this new change in the law only applies to applications that are being filed October 1st or later. So for now, or for last year, if you had a loved one that you wanted to try to apply for community Medicaid for, so that social services would pay for an aide to come help them in the house, there was not a look-back period. In other words, we could transfer assets from that patient, from the ill person, transfer them to any family member at all, or put them into a trust, and then, I'm sorry, something happened to my screen that I didn't expect. Excuse me, everybody. Okay, there we go. So excuse me for that. So what's happened now is if you want to apply for community Medicaid benefits for somebody, you have to provide a history to social services of financial transactions for the past 2.5 years. And you never used to have to do that for community Medicaid. Again, I'm not going to go deeply into that tonight, but it's so critical for many of us that I had to at least mention it briefly. The other thing that's going to be changing, and this is also a permanent change to the law, is there's going to be a phase out of long-term care assessments. The way social services evaluates an individual's need for home care assistance and the number of hours that social services is willing to provide for a patient is being completely overhauled. And rather than private long-term care insurance companies making these assessments and evaluations, rather the Department of Health is going to be involved in these assessments. There are, to be sure, wrinkles that have to be ironed out here, but it's a major change in the law. I'm going to turn now to changes in the law that are of a much more temporary nature, but striking in their significance. The first one that some of you may have heard about is that New York State is now, and not every state in the country is permitting this. I don't even know how many are, but New York State, as of several weeks ago already, is permitting virtual notarizations. So if you have an important document that needs to be notarized, you do not have to find a notary who has a shop that's open or who's available in a bank and will sit in front of you and look at your identification and then acknowledge your signature face to face. That is no longer required through May 7th. That date may be extended, but as of now, through May 7th, virtual notarization is permitted. It's not necessarily an easy thing, however. Virtual notarization, and I'm going to just turn to my notes so I don't misspeak. Virtual or remote notarization pursuant to New York State Executive Order 202.7 was effective March 19th. And as I said, it extends through May 7th at this point. It applies to any notarial act required under New York State law. So there's not a requirement in this executive order that the notarization be involved in an essential transaction. You know how certain businesses are closed if they're deemed non-essential. The virtual notarization applies to any notarization at all. It doesn't have to be of a particular character. But what this remote notarization does involve is that it has to take place during a video conference, not on a conference call, and not on, it can't be a pre-recorded scenario. Rather, the person requesting that their signature be notarized must present a valid photo ID to the notary during the video conference, unless the person is personally known already to the notary from, I guess, pre-COVID days. The photo ID may not be sent to the notary prior to or after the video conference. The photo ID must be shown to the notary during the video conference. The video conference must permit direct interaction between the person and the notary. So in other words, the type of platform that we're using today, Zoom, is a permissible way to conduct a remote notarization, because we can interact here. If you were unmuted, I can see you, I would be able to see your identification, we'd be able to talk to each other. And this is something that's also very, very important. The person who wants to be notarized must affirmatively represent that he or she is physically situated in New York State during this interactive transaction between the notary and the person who wants to have their signature notarized. There are other requirements here too, but as you can see, there are quite a few steps that need to be followed meticulously. And so, although I would offer this service to my existing clients and close friends, it's certainly not something that I'm gonna advertise widely through New York State, because the potential liability for a notary is already great. If you do something wrong as a notary, you can be liable for the value of the loss to whoever loses out in the wrong transaction. But these rules have to be followed rigidly. The other reason that I wouldn't be too anxious to do too many virtual notarizations, and certainly not for somebody I don't know unless they really needed my help, is because we don't have case law yet on this. There are little gray areas and nuances here that we don't really know how they're going to play out in the courts later. If something very important has to be notarized and there's no way for the person signing to get physically to a notary, call a notary, see if they'll do the virtual notarization for you. As I said, this would be a service I'd offer to my clients and close friends. And the other thing that I would offer is, once the lockdown is over, I would want to meet with that person and see if we could re-notarize and firm up whatever we did remotely. The next change to the law, which is of a temporary nature, but very, very significant, is in New York State, we are now permitted to virtually or remotely witness wills and other documents that require witnessing. Previously, the relevant statutes in New York State, the Estates, Powers, and Trusts Law, requires, and I'm going to read a little part of the relevant statute, the signature of the testator, that's the person who's about to sign their will, the signature of the testator shall be affixed to the will in the presence of each of the attesting witnesses, or shall be acknowledged by the testator to each of them to have been affixed by him or by his direction. So very few lawyers permit an acknowledgement by the testator afterwards. The law virtually requires that the testator, the person signing the will, be sitting right in the room with the witnesses to the will, that everybody watches while everybody signs, and that's the way you do it. Anybody who's signed a will that I've supervised the execution knows that there's a little ceremony we follow, and I don't deviate from that at all. Other documents that need to be witnessed are a healthcare proxy, a power of attorney, a living will, and there are lots of documents that we sign when we're conducting legal business that require witnessing. Similar to the remote notarization, however, the remote witnessing must be conducted via video conference, subject to a lot of rules. The person requesting that their signature be witnessed must present valid photo ID to the witnesses during the video conference, unless the person is personally known to the witnesses. Once again, just like with the remote notarization, the photo ID may not be sent to the witnesses prior to the video conference. The photo ID must be shown to the witnesses during the video conference. The video conferencing platform must allow for direct interaction between the person and the witnesses and the supervising attorney, if applicable. Pre-recorded videos of the person signing are not permitted. The witness must receive a legible copy of the signature page, which may be transmitted via fax or other electronic means on the same date that the pages are signed by the person. So now the language is starting to get sticky, so I'm going to stop. I'm not going to read any more of that. Suffice it to say that it's not simple, okay? And again, there are gaps in the law, there are gray areas. If it has to be done, it has to be done. And it certainly is a service that I'm providing during this time, but I'd rather not, because there are gaps in the law and there are gray areas here that have not yet been ironed out in the courts. One ambiguity here is the executive order that permits remote notarization states specifically that the person requesting that their signature be notarized must affirm during the video conference that he or she is within New York State at that time. There's no such requirement under this executive order that applies to remote witnessing of documents. I don't know how that's going to play out in the future. Are we allowed now to remotely witness a document, a New York State document, for somebody who's in Alaska or in another country? This is silent. So again, this is something that, unless necessary, I would rather do things the old-fashioned way, but I guess we'd all rather be, you know, out and about conducting our lives the way we used to also. So after telling you a little bit about, you know, these temporary emergency laws that the governor has enacted, the virtual notarization and witnessing, I'm just going to throw out that there are other ways to get your estate plans consummated and certain important legal work done without all of this technology. And then the obvious issue with a lot of my clients, because I deal often with elderly people or people who, like myself, are not 100% comfortable sitting in front of a screen and conducting their lives remotely like this. It's the technology level. The testator, the person signing their will, the person who needs their signature notarized, they have to have some level of technology skill or be quarantined with somebody who does, such that they're able to sign and scan documents to the witnesses or to the notary. That type of technology skill is not within the reach of everybody who needs to have emergency documents signed, notarized, and prepared for them. To the extent that I can help with that sort of thing, I'm certainly here for it. But again, that's another difficulty with these remote practices that have been permitted. So again, I was just going to mention other ways that we can conduct essential legal business. And in many cases, putting together your estate plan is essential. We have people now who find themselves believing that they're more likely to die soon today than they were before the lockdown began, for example. So it could be very important that, or to lose capacity, even if they don't die. So it could be critical for people today who don't already have certain documents in place to get them done. The healthcare proxy, where you appoint an agent to make medical decisions for you in case you can't do it. Your will, in case you die, what's going to happen to your assets that don't have beneficiary designations attached to them. So two other services that we provide are open air signing ceremonies, where we set up a table, and Sarah knows because she's helped me through one of these. We have to make sure that the weather accommodates, but we can actually set up a table and chairs out of doors. And as long as we are all protected with our masks, with our gloves, and with our social distancing, and follow the rules that now apply to social interaction, we can get your documents signed. And it's very important, especially when you have somebody who's elderly or frail or just very nervous because of what's going on. We can get these things done. It's sort of an odd circumstances, but it's certainly easier for some people to do it that way than it is to try to do it remotely, relying heavily on technology. And the other way that we can get essential documents signed is it's just another version of the curbside signing ceremony, but I've actually, it's another version of the open air signing ceremony that I am calling, because I do have a sense of humor, curbside signings. And I had a couple pull up in front of the office just the other day, a couple very close to me. I don't know if they're watching or not, but I love you both, you know who you are. And the wife of this couple is one of our first responders in the healthcare field, right? So she's being very cautious. She's going into work every day. She's coming back. She's bleaching her shoes. She's leaving them outside for 2 days. She's taking a shower before she interacts with anyone. And she's married to somebody who finds himself in one of our at-risk categories. So they needed to put their estate plan together. And so what we did is I met them in front of the office with 2 witnesses, and we stood apart and I issued directions on how they could do what needed to be done. And without even leaving their car, we were able to conduct a complete signing ceremony, and they drove off having signed wills, healthcare proxies, powers of attorney, and all the documents that they needed to help them feel secure before she got dressed to go back into the front lines, you know, for us in the healthcare field the following day. So I've got goosebumps just talking about it right now, because this is one of the privileges I have as an attorney, is to be of service to people in unique situations sometimes. Back to the laws that have changed recently dramatically, but on a temporary basis. I don't know if you're aware of it or not, but all statutes of limitations in New York have been tolled. All statutes of limitations. So for example, if somebody wrongs you in some way, and the statute says, and don't ask me questions about what's the statute of limitations for this and that, because I forget most of them. But let's just say you discover that somebody committed fraud on you at some point. And so you need to commence a lawsuit against that person or that entity within a certain period of time, or you lose that cause of action. You lose the right to recover from that person who wronged you once it's discovered through the courts that they actually did wrong you. All statutes of limitations have temporarily been tolled. So if you discovered a year and a half ago that somebody wronged you and the statute of limitations was gonna toll on April 16th, if you didn't commence your lawsuit today, that does not apply. That has been told until at least May 7th, maybe later. But we have to double check. Statute of limitations is a very serious thing. I believe it's May 7th. I could be wrong, and it could also change. But just be aware that the statute of limitations, in case you or anyone you know was involved in some sort of a lawsuit and felt that you had to file right away, you have extra time in that case. Of course, that's an emergency measure that is going to evaporate along with the lockdown. Most courts are closed. If you're not involved in any court cases right now, you might not have been aware of that, but most courts are closed except for emergency proceedings and actions. Pending criminal cases, pending civil matters as well. Most of them, the last I heard as of 2 weeks ago, if the jury had already been picked and they were already, on their way to trial, those cases, I believe, continued to snake through the courts. However, no new civil cases are being heard by judges unless they are emergency matters. How does that apply to me specifically, to a trust and estates attorney, to an elder law attorney? Well, a lot of what I do for clients is I help them open estates, whether somebody died and there's a probate proceeding or there's an administration proceeding because there was no will. The surrogates courts locally are not entertaining any new petitions, whether they're administration proceedings or probate proceedings. This could change. Things are changing all the time. But as of today, no new probate or administration petitions are being heard unless you prove as the petitioner that the estate must be opened so that assets can be reached to pay funeral expenses. The undertakers are on the front lines or the back lines, whatever you want to call them. They are inundated with serving our community and, in a heartbreaking way, of course. And they are entitled to payment for their services. And very often, the money needed to pay for those funeral or funeral-related services cannot be accessed unless an estate is opened and a person is authorized to act as administrator or executor and to get funds to pay the funeral director. Those proceedings are being entertained by the Surrogates Court of Nassau County at least. I'm not sure about Queens, Suffolk, and the other counties, but I know in Nassau County they are. Real estate closings, I'm just going to briefly mention that real estate closings can proceed because virtual notarization is permitted. However, nobody's recommending that you put your house or your apartment on the market today because you can't do public showings, and it may be difficult, if not impossible, to get an appraiser to come in. You might not, hopefully you won't find anybody to come do non-essential repairs or painting or whatever you ordinarily want to do to a residence before you sell it. But if you're already in contract, a real estate closing that's already in contract is able to go through and be consummated. So that's my summary of changes to the law as they affect trust and estates and elder law. And before I move into planning for the unexpected hospitalization or separation from family, I guess I'll run the risk of asking if anybody has a question about anything that I've discussed so far. If you do, if you know how to access that little blue hand and raise it, Nelson will tell me if anybody has their hand up. And if nobody does, that's just fine, because these are new laws that, I'm just finding out about myself. So I don't have years worth of experience handling these recent changes to the law. So now I'm going to move along to planning for the unexpected hospitalization or separation from family. Why plan for this type of hospitalization or unexpected separation? Because this is the world we're in right now. This is what's happening. If you have not found yourself in this situation, or if nobody close to you is aware of this already, you're in a very lucky situation. Because most of us have experienced an inability to visit somebody that we care about who's in a nursing home. Visitation is not permitted in nursing homes today in New York State. Visitation in hospitals is generally not permitted in New York State because they want to prevent the spread of the virus that causes COVID-19. So what's happening is the only visits that I'm aware of that have been permitted are where the patient or the resident is in the active stages of dying. In that case only, the facility will permit the next of kin, one at a time, maybe even one. Like, I don't know how they determine on a case-by-case basis who's going to get in to see, the person, or just, who's dying. But one person will be permitted a brief, maybe an hour visit with the person who's actively dying. And that's what they're permitting. So what can we do in the face of that unexpected situation? Well, One of the things that we came up with was a vital information form. And Nelson, if you want to put that on, I'll start talking about this. And, you know, this is one of the documents that if anybody's interested in having a copy of this, we'll certainly make this available to you after tonight's presentation is over. The form begins by asking some very general information: name, address, cell phone, hair color, eye color. You can fill this out to the extent that you feel comfortable. For example, if I'm filling this form out for myself, I'm not going to voluntarily disclose my weight because I never do. That gets, you know, that's not information I would put on a piece of paper. But you may put it there for yourself or for your loved ones. You can modify this document as needed for yourself. There's a line toward the top of the page also that says, keep this information secure: date of birth, social security number, phone PIN, in other words, the passcode to get into your cell phone. You may or may not want to fill that out. In fact, you may want to have two versions of this form. If I have somebody that I'm caring for on a regular basis, I might want to fill this form out without putting all of the vital information on it. And if my loved one winds up having to be hospitalized for any reason, I can give the almost completely filled out version of the vital information form to the EMS driver or whoever accompanies my loved one to the hospital, because they're not going to allow me to travel with them in the ambulance or even to visit them during admission. So I can keep the completely filled out version of this form with me at home. So if I need to share this information with the nurse or whoever else calls from the hospital, I'm going to have all of this vital information at my fingertips. So you can decide who you want to use this. A form like this is most important if you have a loved one who is suffering from memory loss, has Alzheimer's disease or dementia. In a case like that, your loved one will not be able to be terribly helpful to the healthcare professionals on admission or during the hospitalization. So all the information that you can allow to travel with that person to the hospital, the better. If you don't give it to the EMS driver, you'll have all the information here ready to email or fax to the hospital when they ask it. But filling out this form is going to turn out to be a very helpful exercise because you may need this information. If you look at, so page 2 was asking for other information about diabetes, COPD, asthma. These medical conditions are all the more important today during this COVID crisis that we're in, but it's just as relevant really at any other time. We're asking that you put down surgeries, hospitalizations, insurance information, primary care doctor, and on the top of page 2, additional physicians, specialists with their phone numbers and what the specialty is, case manager or social worker information if applicable. And then this is key: next of kin or persons to be notified in an emergency. You know, as I said, this is a form. Forms are meant to be tailored to your specific needs. But this form can help the doctors know who to contact. And if they can't contact the first name you put down here, hopefully they'll have a second name or a third name. We're all at home, so it's not that hard. But let's just say the phones go down, or, you know, most of your household is engaged in essential work, so they're not 100% easy to reach. The more people you can put down here as emergency contacts, the better. In the middle of page 2, we ask, have you prepared these legal documents? Attach a copy, we suggest, and instructions on where to access the originals. If you're one of my clients and we've prepared a will or advanced directives for you, if we haven't already emailed electronic copies of those documents to you, let me know and we'll send them to you. You can put them on a thumb drive or you can keep them on your smartphone or in your PC. someplace that's readily accessible, so that should there be a need, somebody will be able to send your documents immediately to the hospital. The living will, or the healthcare proxy in particular, is what I'm thinking of. A little bit further down on page 2, we ask for a medication list. And thanks to my good friend Barbara, we're asking not only for over-the-counter and prescription medications, but vitamins and supplements. You know, Barbara reminded me, she said, do you have supplements down there? And I said, gee whiz, no. So we're asking for supplements as well, because doctors often want that information. On the very bottom of page 2, there's another little box that I'm going to talk about, and then we'll really be done with this form for today. But it says, please fill this out if the information being provided is for a person lacking capacity. Well, who lacks capacity? Generally, that could be a minor child, or it could be a ward. For example, I am the guardian for several adults who've been adjudicated incapacitated. So if I have a form like this traveling to the hospital with one of my wards, I will check the box that says, yes, I grant permission to treat my ward in an emergency, or no, depending on what the case is. I'll put my name as, the responsible party with my phone number, signature, and I'll check the box guardian so that the court knows my role. And then the other thing I may wish to do is print out a copy of the Supreme Court order appointing me as this individual's guardian, so that they know that I have the authority to act. So that's the vital information form. Thank you very much, Nelson. You can take that off now. And I'm going to jump right into the second form. The other suggestion that we would make is you may want to print out these forms or your advanced directives, if possible, on neon colored paper, so that they really stand out in your little carry bag or handbag, so that people find them, you know, like a hot pink or a neon green or something. I'm going to move along now to the critical packing list, and Nelson will show you that as well. This is not necessarily a form that you're going to send along to the hospital with your loved one. This is going to help you pack a bag so that if your loved one does wind up having to go into the hospital, you know what to put in the bag. So we're suggesting, and again, it's a list, it's a form, so it's meant to be personalized for your needs. But we're suggesting maybe a 3-day supply of prescriptions. I know that hospitals generally don't let you take your own prescriptions, and I also am aware of the fact that they're saying that New York has started to flatten its curve. So now rather than having our hospitals 200% full, they're closer to 100% full. That still means that the people working in the hospitals are very, very busy. So they may not be able to access the prescriptions that your loved one needs immediately. So if you send them along with a few days supply of prescriptions, over-the-counter meds, vitamins, and supplements, certainly can't do any harm. Personal toiletries, extra batteries for a hearing aid. This is the type of thing that a lot of us might forget. An eyeglass cleaning cloth. I usually wear a cotton shirt, so that does the trick for me, but for those of you who are more sophisticated, a cleaning cloth is a good idea for your eyeglasses. Underwear, socks, reading material, pen and paper. You know, if you can't, you may not be able to access your phone to read, you know, to look at Facebook or to read the bad news. Or it may be a loved one who doesn't use a smartphone. A shawl or a light blanket. Again, we're assuming that the hospitals are full and might possibly, despite their best efforts, be unable to provide your loved one with every comfort that you'd like them to have. You want a charger with your cell phone, if possible, inexpensive headphones, and again, in the day of COVID-19, personal hand sanitizer, gloves, face mask. Here we're suggesting that you also pack that vital information form. Again, if you have filled out 2 versions of the form, you put the one that does not include that critical sensitive information like a social security number and a cell phone password in the packing list, just in case it gets into the wrong hands. Advanced directives, you can print out paper copies, again on neon paper is a really good idea, of the living will and the healthcare proxy. You don't need the will, the last will and testament. You probably won't need a power of attorney, but the living will and the healthcare proxy could be important documents for your loved one to have in the bag when they're in the hospital, either in paper form or digital. Digital could mean readily accessible on a smartphone or on a thumb drive, or just accessible by having the hospital personnel call somebody back home who would be able to then email these documents. And last but not least, if your loved one or you has a pacemaker, a port, or a pump installed, it's a good idea to add in your critical packing list a booklet or other sheet of paper that includes the brand and model number of these implants, just to avoid unnecessary delay in treating you. So now I'm going to ask that Nelson please post, we're done with that list. Why don't you just give people an opportunity, in case I'm not encouraging anybody to leave early, but in case people do, Nelson, why don't you offer them our phone number and email address in case people already know that they might want to contact us at some point for copies of these forms we've shown them. Here you see, here's our email address, phone number, Facebook. We love Facebook. Like us, and you'll get a lot of good articles and information through Facebook from us. And while you're looking at that, I'm going to encourage anybody who has questions so far to raise the little blue hand. I don't know, Nelson, can you see the hands raised even while you're sharing a document? Oh,
I'm not sure if I can.
Up. So I can see the hands go up. Ilgar, do you have a question?
No, I was just going to tell you maybe we should unmute them in case people want to ask question. It's muted. Okay, that's it.
Okay, thank you.
I think I can unmute.
Okay. And Nelson, maybe why don't you take this down? We can put it up later. So somebody might actually be raising their hands or physically indicating to have a question.
But I can't really do it as a, I can't really do it.
Okay, please unmute everybody again. And just, Nelson, if you could scour the audience and see if anybody, oh, here, somebody's got a hand up. Do you know who that is? Maureen Gradovsky. You can also use this chat for questions. That's true. But I'm not going to be reading the chats right now. Nelson can read them. So, Nelson, do you see any questions that you want to?
It only has it has member, address, city, state, zip, phone, CB, email, aid, and then it says 2017, or whatever that means, that column. List, business name.
Nelson, can you please mute everybody and just check the chat to see if anybody has a question?
Nobody has a question, but Phil, were you asking something? Phil? I heard Phil talking, but I'm not sure.
It looks like Samsung Galaxy was raising her hand, Annabelle.
Hey.
Did you have a question?
Yes,
Samsung
I have
Galaxy?
a question. I have a question.
How can I help you? What's your question?
Okay. Are you able, can you hear me?
Yes.
My name is Delilah. Are you able to send us printable version of the vital information form and the critical packing list? I'd like to print those.
What's your email address?
Are you ready?
Yes.
I'll write it down, Annabelle.
Okay.
And then they'll get an email.
A like Anthony, and then RASHAD@AOL.com. And if you can send me the PDF, I can print those.
Okay.
Yeah.
arashad@aol.com.
That's it. Thank you.
Great.
Thank you.
Sure, no problem.
And if you don't hear from us quickly, send me an email just in case we got your email address wrong, but we'd be more than happy to send that to you. Any other questions before I move along?
I would also like a copy.
Who's
Hi,
that?
This is Cynthia.
Sure. Give us your email.
It's
Why don't, can
my
you put
name.
it in the chat?
Cynthia Terrell.
Yep.
It's Cynthia Terrell at yahoo.com.
That's easy. Thank you, Cynthia. Thanks for joining us today. Cynthia Terrell. Got it. Anybody else? Oh, Ilgar has, I'm going to lower
no.
your hand.
No, it's fine. Sorry.
Okay. Oh, no problem. Anyone else? It looks like we don't have anyone else, Sam.
Can I say something?
Of course. Barbara?
This is Barbara. Annabelle, thank you so much. You know, this is so important at this time to review this stuff and to be made aware of, you know, none of us know what tomorrow brings. And we're hearing people that you would never think are going into the hospital under, you know, circumstances now with this COVID virus. That, thank you. I'd like to be able to send that to some of my clients, if I may, you know, just to keep, to pass it on, because Marty just said to me, Barb, boy, even that list of, you know,
things to go in the hospital with.
Yeah, to bring to the hospital. So important. Thank you so much. Really appreciate it. Very
welcome.
Presentation.
And thanks for helping to develop the form with your suggestion. And Nelson's also going to be developing a fillable version of these two forms. So we'll have those for you as well. But for now, we'll send you the PDF versions so you can distribute them as you wish. Hey, Marty, how are you?
Hi, Annabelle. Great. Nice to see you.
All right. So I'm going to talk now about a few more things. It's almost 8 o'clock. And I just want to talk a little bit about advanced directives, and which I view now during this COVID crisis period as being literally more important than ever, because we hear on the news, and I hear from my own loved ones, that this COVID-19 really manifests in very different and unexpected ways with different people. Nelson, could you please mute everybody?
Yep.
You know, sometimes a person seems to be, they're deathly ill. I got a call from a cousin today about a close family member who all of a sudden is in liver failure. So we just never know. So we need to be prepared, because as we learned in Weight Watchers, and that's probably the only thing I learned, was if we fail to plan, we plan to fail. And I think it's really very, very true in many cases. So what is an advance directive? An advance directive is a document that we use to direct people in advance. It's an advance directive. So a living will, for example, is a document whereby I can tell you today, in advance of any need for it, what my wishes would be in the event that the living will becomes important for people to look at. And the way the living will begins is being now of sound mind, and that's critical. So it's very important for us to do a living will today while we are of sound mind, because we don't know, as Barbara said, what tomorrow may bring. We don't know what next month may bring or next year, not just for our loved ones, but for ourselves. So being of sound mind, and once a person is no longer of sound mind, unless they revert back to being of sound mind, which sometimes doesn't happen, in that case, it's too late to do these documents. So it's never too soon to prepare your advance directives. You can change them. You can change them as often as you want. But if you don't have these advance directives in place, if you lose capacity, the law will step in and make these decisions for you. So the living will, being now of sound mind, I, Annabel Bazante, here state my feelings regarding medical treatment in the event that I am unable to participate in such decisions. So that's very important. As long as I am able to participate in my own medical decisions, I'm my decision maker. The doctor is going to ask me, what do I want? What do I not want? But if I am unable to participate, what are my directions that I'm setting forth in this living will? Well, this is what I'm asking. If, due to injury or illness, I become extremely disabled, and it appears that there is no reasonable expectation, 1, of my recovery, or 2, that I will regain a meaningful quality of life, then in that case only, I direct that no medical treatment be initiated. If at that time medical treatment has already been commenced, I direct now that at that time such treatment be discontinued. I have the right to make this direction. Now, I'm not going to read the entire form, and as with most legal forms, there are ways to personalize this so that it's more suited for you than for somebody else. But the living will does not have the force of law. Nobody can take a living will to the court and say, Annabel said that she doesn't want to be hooked up to an artificial respirator if it appears there's no reasonable expectation of her recovery or that she'll ever regain a meaningful quality of life. The living will rather serves as very strong evidence of my intentions, of my wishes. And the person who's going to act on that intention is going to be perhaps my doctor and definitely my healthcare agent. Now, the healthcare proxy is the advance directive that you would use to appoint a person to act as your healthcare agent. Again, just as the living will, only in the event that you are unable or unwilling, only in the event that you are unable to make your own healthcare decisions. So this is how part of the healthcare proxy reads. In the event that I become unable to make my own healthcare decisions, this healthcare proxy shall take effect, and I hereby authorize, again, I'm authorizing in advance what my directions are going to be for the future. I direct that my healthcare agent shall make any and all healthcare decisions for me, except to the extent that I state otherwise on this healthcare proxy. So you can tailor this. You can say certain things in your healthcare proxy that somebody else might not want to have. For example, my healthcare proxy says very clearly that I hereby make an anatomical gift to be effective on my death of any needed organs and or tissues. Organ and tissue donation is something that's very important to me. My mom was a kidney donor. She gave her own sister the gift of 17 years of life by giving her a kidney. So that was the example set to me by my mother, and one that I would be honored to follow if the opportunity arose. Of course, I'm not looking for the opportunity, but this is something that's important to me. Judgment-free. There are people who, for religious or ethical or other reasons, or just discomfort, don't want to make an anatomical gift on their death. You don't have to. This can be tailored to suit your needs. I also have a special version of healthcare proxy that I use for my clients who are Jehovah's Witness. They have a whole different set of rules that they follow when it comes to things like this and their healthcare decisions. So we respect wherever somebody's coming from and whatever their preferences are. So you'll name an agent to make decisions in the event, only in the event, that you yourself are unable to make your own healthcare decisions. I strongly suggest to everybody who comes to me that you not only appoint an agent, but a successor agent in case the first agent is incapacitated or dies before you do. I also strongly recommend, if possible, that you come up with an alternate successor healthcare agent in case neither of the first two are able to act. Now, the inability to act may be their death, their incapacity. They may just decide that they can't make that decision. They could just get freaked out when it comes down to it. We don't know. So if you can name several alternates, you're doing yourself a service. Under New York state law, you may not name two agents to serve simultaneously under a healthcare proxy. The law is frequently not intuitive and not logical, but to me, that makes sense. We don't want two people arguing over, yes, she should have this. No, she shouldn't have this. Yes, this is life and death and health, and this is more important than money. This is your life. This is your medical decision making. So only one person. The other thing I include in my healthcare proxy is the power that we give your agent, only again, if you're unable to make your decisions, to inspect and disclose health-related information. They would have the rights that normally somebody other than you doesn't have under the HIPAA regulations. The third advance directive I'm going to talk about before we really end tonight's meeting is the power of attorney. Now, I always talk about the living will and the healthcare proxy first, because to me, they are the most important documents I can help a person put together. They, as I said, have to do with life, comfort, death, these types of vital decision-making. The power of attorney is also important, but it doesn't involve healthcare decision-making. By using a power of attorney, you would be authorizing somebody to act as your agent with respect to your property and financial affairs. Again, you can tailor it to your own needs. Generally, what I do is I suggest to my clients, as long as you have an agent that you really trust, give them as much power as you can. Because again, planning for the unexpected. We don't know today what may make sense for them to do tomorrow on your behalf. We just simply don't know. So to the extent that you can, I would suggest pick an agent, of course, who you really trust, give them the maximum power permitted by law. Again, you know, I don't prepare these documents for anybody unless I've made them engage with me in a rather in-depth consultation, so I get to know you and your family and your assets, and I know what makes sense to recommend to you or not. But generally, for most people, I do suggest that you give broad powers. If, however, you don't have somebody that you trust 100%, but you want to authorize somebody to do some limited transactions on your behalf, you can do that too. I'm going to take one moment to speak to the agent under the power of attorney in the attorney in fact. The power of attorney form itself is way too long. It's about 14 pages. Many people don't read it all the way through. I don't blame you if you don't, but there's a lot of important stuff buried in this document. If you are appointed to serve as the attorney in fact for somebody, that means for their agent pursuant to a power of attorney form, that's what attorney in fact means. It is critical that you, number one, act according to any instructions from the principal or where there are no instructions in the principal's best interests. So if that principal, if your friend, if your spouse, if your parent, whoever it may be, has told you in advance, remember it's an advance directive, has told you in advance how they would want you to meet a certain, to respond to a certain set of circumstances, that's how you, acting under this document, are to respond to that set of circumstances should they arise. However, if something happens, like whoever expected to be in a lockdown, like I still sometimes can't believe what's going on right around us. This we couldn't expect. So it's possible that as attorney in fact for somebody, I'm facing a set of circumstances today that we never imagined in advance. So I would make a decision based on this unique set of circumstances and behave in my principal's best interests. Under the power of attorney, you may name more than one person to serve simultaneously, unlike under the healthcare proxy. You can have 2 agents serve as attorney-in-fact. And if you do pick 2 people to act, for example, your spouse and one of your children, you can further specify that you either want those 2 people to always act uniformly, so any document is going to require 2 signatures, or you can choose that my spouse and my child are my co-attorneys in fact, but they are each authorized to act independent of each other. You can do it either way. There are a lot of nuances in the power of attorney. I think one of the last things I'm going to say, but then stuff comes up as being important, is it's critical that as the attorney-in-fact for somebody, you keep a record of all receipts, payments, and transactions conducted for that principal. I don't care what your record keeping is for yourself. You must keep meticulous records for your principal if you are the attorney-in-fact under a power of attorney. Very, very, very important. And I think that's about all of the substantive material I am going to present for you tonight. You've been a wonderful audience, and it's already after 8 o'clock. And I welcome you to participate in the second part of this series, May 28th at 7 p.m. We're going to be discussing, heavens, I forget what, but it's going to be really good, whatever it is. We're going to be talking about simple wills versus good wills, number one. You know, the way I look at it, simple wills are for, I'm not going to say simple people, but simple wills are for simple circumstances. And some of us do have simple circumstances. Most of us don't. I think it's very helpful to talk to a qualified attorney before you sign a will for yourself. I have spent many hours and weeks and months helping people litigate their way out of documents that they downloaded from the internet, which really wound up in the end not serving them well. In some cases, they work just fine. In some cases, they don't. So, you know, you do whatever you want with that. And then we're going to talk more about elder law planning and Medicaid eligibility planning. So does anybody have any question at this point?
We're all muted now.
Selena has a question.
Yes. My question is, if I have advanced directives, do I necessarily need a healthcare proxy? And if I have a living will, do I necessarily need a power of attorney?
Thank you for that question. It's an excellent question. Every one of those documents serves a distinct purpose. The living reference to not have your body kept alive through artificial means if you wind up in a situation where you are very disabled and the doctors have determined that there's virtually no chance of you ever recovering to the extent that you'll have any kind of meaningful quality of life. No doctor can ever say, you're never going to recover, because that's not for doctors to say. But if they determine that there's virtually no chance of you coming out of that vegetative state or comatose type state, in that case, the living will set forth that intention. The healthcare proxy is where you appoint an agent to make medical decisions for you, and that agent will serve only if you're unable to make medical decisions for yourself. So the difference is, the living will is a statement of your wishes not to have your body hooked up to artificial life support if you're in a really bad way. The healthcare proxy states your desire to have so-and-so serve as your healthcare agent in the event that you're unable to make decisions. And the power of attorney is different. It's similar to the healthcare proxy because you're naming an agent to act on your behalf, but it's different from the healthcare proxy because the agent you name in the power of attorney will be making financial and property decisions for you, not medical or healthcare related decisions. It's different in Florida. They have documents that sort of, they have different types of documents that are sort of hybrids of what we use here in New York. But in New York, these are 3 distinct documents serving 3 different purposes. Did I answer your question?
Yes. Thank you.
Great. You're welcome. Any other questions? Okay, I hesitate to end in case somebody is
Hi,
blue hand.
Annabelle, Barbara.
Okay, hi, Barbara.
I don't have a question. You made clear some very important differences between the documents. I appreciate that. And you made me aware, because of the crisis, that I thought I had plenty of time to do this kind of stuff, but I don't. I have to consider it. So I will be in touch. I have some of those similar documents from my union, but I want to thank you for a fabulous presentation. And for anyone who doesn't know Annabel well, she is very accessible. She's very responsive. And if you're here, you probably know that already. But if you're just here to check her out, she's quite responsive and knowledgeable, and you would make a great choice in choosing her to help direct you in all these areas. Thanks.
Amen.
Barbara, thanks for being here.
Thank you. Thank you.
Thanks, everybody. So maybe before we part, Nelson, do we need to put up our contact information again, just in case?
There you go.
And I'll mention again, although you can find out from Ilgor that we're going to be presenting another part of this talk, of course, addressing very different topics on May 28th at 7 p.m. And if you contact us or if you contact the Uniondale Library, we'll give you registration information when it becomes available.